Okay. Hello, my name is Arif Raditya with Mala, Suzy Avengers 088. And today I will present about a topic that is about the challenging the framework of employment relations. Okay, so let's just get into it. The first part is introduction. So this chapter describes the current framework of British labor law and analyzes its nature and rationale in the light of major legislative change made by conservative government in the period of 1979 until 1970 and by Labour government since 1997. It highlights how European Union law increased cash shape national labor law and the demise of the voluntary tradition and the increasing juridification of industrial relations in Britain. Okay, moving on to the voluntarism and the growth of its intervention. So we're gonna talk about the four things here. The first one is period up to the 1960s, 1960s and the 70s pressure for reform, and 1979 until 97, the legislative break with voluntarism, and last one is post 1997, new labor change and continuity. Okay, so the first one is the period up to the 1960s. Throughout most of the 20th century, British employment uh, British employment relations were largely regulated through collective bargaining between employers and unions, a system known as voluntarism, and this approach favored minimal legislative intervention, with unions seeking protection from court interferences in with an employer's continued freedom for effective law. State law did play a supportive role, primarily to fill gaps not covered by collective bargaining, such as setting minimum wage for certain sectors, regulating um, working hours for women and young workers, and ensuring health and safety standards. However, compared to the industrial countries, British employment law influence remains limited, with the legal profession playing a minor role in industrial relations until the 1960s. Moving on into the 1950s and 1970s, pressure for reform. The 1950s marked the peak of voluntarism in British labor relations, where minimal legal intervention allowed employers and unions to self-regulate through collective bargaining. However, calls for greater legal oversight grew by the 1960s, leading to initial legislation on job termination, worker compensation, and redundancy payment to promote labor mobility. Despite a 1968 Royal Commission, successive government pursued more direct legal involvement. In the 1971 Industrial Relations Act attempted but failed to fully regulate industrial relations, while in the 1960s government introduced a modified voluntarism, emphasizing a self-regulation with a supportive legal measurement. Moving on to the 1979 to the 1970s, the decisive break with voluntarism. From 1979 to 1997, conservative government in the UK marked a significant shift away from voluntarism by using employment law to limit union influences, enhancing enhance employer autonomy, and reduce collective bargaining role in regulating industrial relations. These changes were driven by a neoliberal agenda focusing on deregulating the labor market to boost employer freedom and minimize collective constraints. Uh, the key form restricted industrial action, ended in compulsory union membership, deregulated wages, and reduced individual employment rights. This approach clashes with the European Union more protective labor standards that getting attention as EU directive on issues like gender pay and discrimination require the UK to adopt and certain protection. In the post-1997 new labor change and continuity, when Labour returned to the power in 1997, the debate shifted from whether the law should regulate British immigration relation to how it should do so. The new Labour government upheld the conservative-era policies, such as limits on strike and union governments, but added protection like a minimum wages, aiming to balance employer flexibility with fairness at work. By endorsing this type, the EU social chapter, uh, Labour signaled as new policy direction, although it did not fully respond to the pre-1970s to support the collective bargaining. Moving on to the next one is individual rights, managerial prerogative, and worker protection. Here we will talk about three things. The first one is rationale for action, justice, efficiency, and competitive. The employment relation inherently involves a balance of power, with employees in subordinate position to employers. Traditionally, collective bargaining addressed this inequality, but from the 1960s, law began increasingly limiting employers' control, particularly in areas like anti-discrimination and unfair dismissal. Conservative government, however, promoted a more flexible labor market by weakening individual workers' protection to stimulate job creating, arguing that statutory protections impose costs on employers. Under a Labour from 1997, legislation emphasized a fair minimum standard while balancing flexibility with social justice through avoiding heavy employers' burdens. And the second one is individual employment rights, nature and scope. So, in 1997, employers in the UK had statutory rights covering notice periods, dismissal procedures, equal pay, and protection against discrimination. The incoming Labour government expanded protection by introducing the new national minimum wages, rights for whistleblowers, paid annual leave, and limits on working hours. The EU, or European Union, directive influenced new rights such as the new Working Time Directive, which regulated influence new which the which regulated maximum weekly working hours and provided rest periods. And Labour also extended the maximum weekly working hours and provided an extended anti-discrimination law, to cover sexual orientation, religion, age, and disability. A focus on family-friendly policies led to parental leave, flexibility working option, and extended maternity and paternity leave. Moving on to the last one is the impact of individual rights. So, in the post-1997, individual employment rights in the UK have enabled employees to seek redress through employment tribunals, fostering more standardized workplace procedures and curbing discriminatory practices, especially in recruitment. However, managerial power remains largely intact, offering limited job protection and despite legislative advances like anti-discrimination and equal pay laws, and issue persist, particularly affecting women, ethnic minorities, and other disadvantaged groups. The introduction of the national minimum wage and family-friendly policies has supported low-income and part-time workers. Uh, has supported low-income and part-time workers, to many of whom are women. Through the practical effect of this measure varies by employer on sector. While most employers report positively on flexible accommodation, flexibility relies on the HOC agreement rather than formal policy. Okay, so the next one is collective rights, collective bargaining, employer representation, and industrial action. So the process of re-regulation by the post-1997 Labour government was not simply a question of enacting additional individual employment rights, and in the name of promoting partnership, the Labour government introduced important new statutory provisions affecting collective bargaining, employer representation, and information and consultation, while largely retaining its predecessors, legislation restricting industrial action and regulating unions' internal procedures. So here we'll talk about six things. The first one is stationary trade union recognition. Uh, the Relations Act in 1999, introduced by New Labour, creates a legal route for unions to gain employers' recognition for collective bargaining on pay, hours, and holidays. This legislation marked a departure from the previous conservative, but included significant employer concessions. For instance, it exempts firms with fewer than 21 employees, and union must meet a minimum 10% membership threshold and security majority support for recognition. The next one is a right to representation. A British legislation protects the freedom to join or not join trade union. The Relations Act in 1999 banned employers' blacklist of union activity for unlimited inducement for workers not to join unions. However, there is no statutory right for unions to organize outside the recognition procedures. A significant individual right from 1999 Act allows workers to be more accompanied by a union official or colleague during disciplinary and grievance hearing, even if the union is not recognized. The next one is stationary information and consultation provision. Driven by primarily by EU requirement, UK legislation has increased statutory provision for employers to inform and consult employee representatives regardless of union recognition. The information and consultation of employees in 2004 marked a significant shift away from the traditional UK practices. Previously, consultation was limited to recognized union representatives, but amendments allow for elected employee representatives when unions were absent. These changes were introduced issue-specific representation mechanism, although some employers struggle with organization election. And the fourth one is the impact of recognition and ICE procedures. The 2000 statutory trade union recognition procedures led to a rise in union recognition agreement, with 2,331 agreement covering 7,225 7,800,000 workers by 2004. However, by September 2008, the CAC had received 680 applications, and overall union recognition continued to decline, particularly in small workplaces. The 2004 WERS indicate that only 27% of workplaces recognize unions for pay negotiation, down from 33% in 1998. While statutory recognition has established formal bargaining relationship, agreement often focus on limited issues like pay and hours. Outcome for union management relationship have varied, with some experiencing weak recognition and lack of collective agreement. The introduction of the ICE regulation in 2005 raised concern about undermining union recognition, but some evidence suggested that increased formal consultation, especially among multinationals. Moving on to the next one is the legal regulation of industrial disputes. In the UK, industrial action lacks an inherent legal right, instead relying on statutory protection or immunity, which shield unions from legal repercussion when strikes pertain to specific employment disputes and meet strict procedural requirements, like securing majority support through ballots, and introduced in the early 90s that expanded over time. These immunities were curbed by conservative government in the 1980s and the 1990s, who viewed them as a special privileges. And the last one is the legal regulation of internal union affairs. In the traditional British industrial relation framework, trade unions enjoy significant autonomy, with minimal statutory oversight of internal affairs to maintain union independence. As noted by Hanif Brun, except for certain financial and amalgamation rules, union largely set their own procedures. However, conservative government in the 1980s and 1990s introduced legislation mandating secret ballots for internal election and internal action, aiming to make union more democratic and moderate. Okay, so the next one is the study case. I choose the study case about Uber versus Aslam case in the United Kingdom. So the short explanation of this case is that in 2008, in 2016, Uber drivers led by Yasin Aslam and James Farrar argued before UK employment tribunals that they were workers rather than independent contractors, which would entitle them to the rights like minimum wage, paid holidays, and race breaks. Uber maintained that its drivers were self-employed, independent contractors who used the Uber platform to find passengers rather than employees of the company, and the case went through multiple appeals until it reached the UK Supreme Court in 2021. And then the outcome of this case is that the UK Supreme Court ultimately ruled by Uber drivers are indeed workers and not independent contractors, making them eligible for certain legal protection under UK employment law. The court based its decision on several factors like Uber's control over fares, trip assignment, driver ratings, and other conditions, which indicate a relation closer to employment than through self-employment. And then the implication of this case is that this ruling marks a significant change in the legal framework of employment relations in the UK, especially within the gig economy. It enforced the need for companies to respect employment rights when they exercise control over working conditions. The case highlights how modern employment law is evolving to adapt to new forms of work and has sparked similar legal challenges in other jurisdictions, promoting a global conversation on employment classification and workers' rights in the gig economy. And last but not least is the conclusion. It's the demise of voluntarism. Since the 1960s, British employment law has shifted significantly towards legal regulation, with both Labour and Conservative governments contributing to what's termed the juridification of employment regulation, where law increasingly influence management practices. Previously, the key areas in British industrial relations were governed by voluntary agreement, but Labour passed in 1997 policies on minimum wage, working time, and union recognition marked a change, embedding a statutory protection. The shift has created a concern among employers over administrative burdens and led unions to seek more flexible legal protection, uh, albeit while advocating fewer restrictions on industrial action. Labour adopted a light regulation, which allows flexible application of legal rights and prioritize employers or employee negotiation over state statutory mandates. EU directive, particularly sees Labour re-entry into the social sector in 1997, have also shaped UK employment law, adding standards for parental leave, part-time work, and information sharing. The EU's influence on UK employment law remains strong, despite conservative calls for further deregulation and potential outputs from the EU social regulation. Okay, maybe that's all from me. I'm sorry if there's any some mistake in explaining the material. Maybe that's all. Thank you everyone for listening.